Please stand with me for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I call this meeting of the Crook County Planning Commission to order. Today's date is March 11th, 2026. The time is 4:01 p.m. I'd like to talk about our process. The meeting is being conducted in person as well as by phone and Zoom. This allows Planning Commission members and/or members of the public to participate in person or remotely. For members of the public, please wait until you are recognized by the chair to offer comments and/or testimony. For those online, if you'd like to speak, please submit a request in the chat function and wait to be recognized. We'd like to thank everyone for your understanding and patience. Minutes and audio recordings will be available on the Planning Commission website. The people joining me are your Crook County Planning Commissioners. We are volunteers that have been appointed by the Board of County Commissioners and make up a diverse cross-section of the community. The Planning Commission will consider the following agenda items. 1, the consent agenda. 2, the continuation for deliberations only, 217-25-000293-PLNG. And 3, the community development updates. Next is roll call for Planning Commissioners. Kirk Giovanni. Here. George Pont. Here. Laquita Steck. Monty Kurtz. Here. Marla Dill. And Hunter Newhart is here. Will staff please indicate for the record which absences are excused or unexcused? I think Mike Warren.
Commissioner Warren's absence is excused.
Okay, thank you. So we're moving on to public comment. Is there anyone in the meeting room or participating remotely that wishes to address an item not on the agenda? If attending remotely, please enter a request to speak in the chat function. Here we are.
Good afternoon, Crook County Planning Commissioners. My name is Robin Hayakawa. I'm an attorney for Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Bend, Oregon, 97703. I want to start by thanking you for hearing public comment this afternoon and, of course, the work you do for Crook County. In the last 2 years, I've been working for Central Oregon Land Watch. I've been impressed with this commission's work, from photovoltaic solar facilities, several of those, to code updates, transportation planning. This commission has treated land use issues facing Crook County with professionalism and care. I've been especially impressed with the proceedings before you tonight involving the application for the Powell Butte Cell Tower. You have convened 4-hour-long hearings. You've consumed copious amounts of testimony, analyzed expert reports, and considered an intersection of state law and local code. And so I bring that up just to say that I don't take the work and consideration that you guys put in lightly, and nor do I take the work of staff, who I know a lot of your success is due to their hard work as well. I don't take that lightly. But with that said, in that spirit, Central Oregon Land Watch is calling upon this Planning Commission to engage in another issue that is of the utmost importance to the community, and that's the conditional use permit for the Woodward Pit off of Stahanchik Road. More specifically, I'm here to urge you to initiate revocation proceedings for the permit pursuant to Crook County Code 18172-100. As I think, or I hope you all know, the conditional use permit for the Woodward Pit was actually issued by this body, the Planning Commission, back in 2015. At the time, neighbors voiced serious concerns about Knife River and the county's ability to protect them from the negative impacts that can come along with mining activity. And to the county's credit, at that time, the CUP for the Woodward Pit was only conditionally approved, assuming compliance with the terms of the permit, but also 31 separate conditions of approval. These conditions ranged from sort of quality of life requirements, like requirements for fugitive dust or operating hours, to other aspects that are quite serious, like groundwater contamination or groundwater protections. Since that time, Knife River has failed to comply with the terms and conditions of that permit in numerous serious and ongoing ways. But you don't really have to take it from me or trust me, you could ask DEQ, who in 2022 fined the company $20,000 after Knife River admitted to discharging commingled dishwater into the Ryegrass Canal, irrigation canal. You could also ask Dogami, who in October of last year sent a memo to Crook County that essentially confirmed Knife River is currently in violation of the terms of their CUP by operating settling ponds on the EFU zoned portion of the property. And you could also ask county staff or the county commission, who have served notices of violations of the terms and conditions of the CUP on Knife River within the last several months. But I think most importantly, you could ask your friends and neighbors who live in the area. Members of this community who live nearby the mine have submitted dozens of code complaints to the county, and some of these people are in the audience today, and I hope you'll hear from them after me. Now, I think it's possible you may hear that this matter is maybe over your head or out of your hands. And I'm here to tell you that that doesn't have to be true. You're an appointed citizen board here to represent the perspective and land use interests of this community. And not only that, but the Crook County Code grants the Planning Commission certain powers, including the ability to, quote, make studies, hold hearings, prepare reports, and recommendations on its own initiative. That's at Crook County Code 18172-080, subsection 8. So what that means is that the Planning Commission doesn't need to wait for staff or the county commissioners to act. The code empowers you to act, and I encourage you to do so. Finally, you may also hear that revocation proceedings could expose the county to legal jeopardy or legal risk. Setting aside that the county is already at legal risk based on the handling of the environmental and public health issue, I think it's important for the Planning Commission to know that initiating the revocation proceedings, it's not equivalent to revoking the permit. It's not a preordained outcome. It really is just the beginning of a due process mechanism that the code provides and would allow the Planning Commission to evaluate a full record and determine whether revocation or modification is warranted under the code. So with that, I would respectfully urge the Planning Commission to direct staff to prioritize this matter by placing it on the Planning Commission's next agenda for public discussion, direct county staff to compile a complete record of the applicable conditions and documented violations, and third, if deemed appropriate, schedule a public hearing at the earliest opportunity to consider revocation of the conditional use permit associated with the Woodward pit. I know I'm over my 5 minutes, so with that, I'll thank you for your time and your consideration. Thank you.
Thank you.
Thank you.
So from here, we take more people. Anybody else wants to comment?
Yeah.
They can come up and speak more. We have one more.
Julie Thompson, Green Valley Road, and I am one of the people that is affected by this mining and the water situation. And I just wanted to do a short story, I guess, in a sense, because I know we've been to the commission multiple times about this. We've gotten nowhere. So we've asked for more guidance from other areas. And I can tell you, I have lived at this residence for 20 years. My grandparents lived there before that. Never had a problem with water. The fall of 22, we were made aware that we had a problem with our water because a very nice gentleman in our area came around and said, look in your toilet tank. And it was full of purple black sludge that you could literally scrape out by the handfuls. So then we decided we should probably get our water tested. So we did. And then it was way above levels. So in the spring of 24, because we decided for a while, we just purchased water for everything. We decided to go ahead and put in a filtration system to make it so that we could drink our water again. It's a very expensive system at 11 grand, and it's probably going to cost about $135 a month to maintain that forever, which was not something that we were thinking we would ever have to do because our water was great before then. Our property values have plummeted out there. We have people that can't sell their houses. We have elderly people in our area that need to probably sell their house sooner than later because they're having a hard time keeping up now. It's kind of their retirement plan that they can't do anymore because nobody wants to buy a place with bad water. There's health issues with our neighbors. I won't go over all of them. I will leave that up to them to share with you if they want to. but health issues that go away once they quit drinking the water. So to me, that's a terrible thing to have to live with and decide if you can't sell your house to get away from it. So you are stuck purchasing water or putting in expensive filtration systems. And some people just simply can't afford that. We're not going to stop trying to get this issue fixed. It's very important, I think, that you guys look at this seriously, because there are a lot of violations, like Robin said. If you went to Lewis and pulled up all the compliance reports of everything that has been done and reported, and you would probably be astonished. I bet it's hundreds at this point. And there's serious things like, dewatering, dumping fines in standing water, the buried materials that are there that may or may not be causing the issues. But where there's a will, there's a way. So we are going to keep trying until we get this fixed. So I hope that you take into account what Robin said. Like, you guys do legally have the right to suspend this or revoke this so that we can pinpoint the exact problem, because I know there are people that do not believe that the mine is the problem. However, nobody had water problems till they mined in the water upstream from us. So I think it would be very wise of the county to at least take a time out until all testing is done to figure out what the problem is instead of letting it continue. Thank you.
Thank you. Thank you. Do we have anybody else who'd like to speak?
Adam Mikulski, 3992 Northwest Tehansik Lane. We met before, 2 weeks ago. I just want to, so I live across the street from the mine. And when this all started in 2015, we sat down with, my wife and I, we sat down with Knife River, their VP. We came up with basically what the CUP was, because this was presented to the Planning Commission from Knife River, but that was the work that we had done with them and prior to it coming to the commission. So we have all these deals in the CUP that are written in there, but yet those were all promises made, but they weren't promises kept. And I think one of the issues we have is, and I'm talking future, is you come up with a CUP, but then nobody tracks it or follows it or make sure that it's being followed, except the neighbors. If you have something, you see something going on. One of the issues we had when we had the hearing for the veneer property, which is next door, is that, well, we didn't have any kind of formal violations or anything like that. Well, the county failed to tell the neighbors, and we didn't see it, that you have to actually fill out a form. We complained, but it wasn't on record because the forms weren't filled out. So then we only learned that maybe 2 years ago. So you're going to see a flood of them recently because we found out that's what we needed to do. But these problems were in the past. That dewatering was done a long time ago. I'm surprised the county wasn't even aware of it because DEQ fined them. But the reason they got caught, and because my wife actually called Dogami and reported it, and then it got to DEQ. So all these promises made, all these things that are getting done, they're still not following the CUP. We're still finding things with dust. Winter, we don't see the dust. Summer, we do. There's trees on the berm. That they're supposed to be taken care of, and all that. There's a lot of you can, if you guys want to see all the violations from Lewis and all that, you can see what's out there and stuff. But if CUP means nothing, and I heard mitigation in the Woodward site. Oh, we can mitigate all this. Well, nothing got mitigated. The dust, all that stuff, nothing. And then we go to veneer, and then the same thing. Oh, we can mitigate that. Well, there is no mitigation because nobody does anything about it. Knife River does what they do. First thing they say, we're not farmers, we're miners, whatever. We can't teach our people for some reason to follow the CUP. I think most of their employees don't even know what a CUP is. So it's the neighbors, it's our frustration. We have to live with it, and we keep coming back. We come back to the commissioners, and here we are again one more time. So it really needs to be looked at seriously. And in the future, on any CUPs, they need to be pretty stringent, and there's got to be some kind of a process to follow up on it other than the neighbors. I mean, I'm sure the neighbors will complain, but something needs to get done that actually people will follow it, because if you don't, why even write one if nobody's going to follow it? Nobody's going to look it up. So anyway, that's my spiel. That was 5 minutes, I think. But I would appreciate what Robin said. Have you guys look at it. It is a big issue, and it's really a big issue when you live across the street from it or in that general area right there. People in Juniper Canyon, people in Palo Butte, nothing personal. They can't see it, but we do, and we see it every day, and we have to deal with it every day. And you talk about being stressful. It's like a scab. You keep peeling it off, and it just keeps bleeding. So thank you for your time.
Thank you. Do you have anybody else who'd like to talk about the Woodward Pit?
My name is Ashley McCormick and I live on Green Valley Road. And this was written with a lot of emotion, so please bear with me. I would like to formally express my deep frustration and concern regarding Crook County's handling of the conditional use permit issued for Knife River on the Stanton Road. The situation has gone on for years, and the continued lack of action from the county has left my family and our neighbors suffering the consequences. The county issued the CUP without having sufficient information about the potential impacts of large industrial operations like this. No meaningful consultation was done with surrounding counties that have experienced managing operations of this scale, nor were adequate safeguards put in place should problems arise. There was no contingency plan and no mechanism for the county to act effectively if a situation deteriorated. Unfortunately, that's exactly what happened. Our water quality has deteriorated significantly. For years, my water tests have shown that my household water is no longer safe to drink. This has created both physical and financial burdens for my family. Despite repeatedly bringing these concerns to the county, we are consistently told the same thing. The county understands there's a problem, but their hands are tied and there is nothing they can do. Being told that we are sorry does not fix contaminated water or protect the health of our families. While we understand that private wells are generally considered the responsibility of the homeowner, that does not mean corporations or permitted operations are allowed to contaminate the groundwater sources those wells depend on. Homeowners can maintain their wells, but we cannot control or prevent contamination occurring at the source of the water supply. No resident should be expected to bear the burden of pollution caused by an industrial operation operating under a county-issued permit. Perhaps the most troubling part of the situation is that the county has openly acknowledged it does not have the time, staffing, or resources to adequately enforce the very permits that it issues. Residents have been asked to monitor the site ourselves and submit CUP violation reports whenever we observe violations. This raises a very serious question. If Crook County does not have the resources or ability to enforce the conditional use permits, then why are they being issued in the first place? A permit that cannot realistically be enforced is not a safeguard for this community. It is simply paperwork that allows harmful activity to continue without accountability. Instead of enforcement coming from the county, residents with full-time jobs have been asked to act as compliance officers. Meanwhile, the company operating under this permit has already received fines from Oregon Department of Environmental Quality for violations at this very site. Month after month, we attend county commissioner meetings asking for help. Unfortunately, the responses have been minimal and ineffective at best. Writing a letter, suggesting residents write letters, or mentioning the issue at lunch during a conversation does not constitute meaningful action. If residents had not continued showing up, speaking out, and pursuing outside avenues, including contacting DEQ, senators, and the media, this issue would likely have been forgotten entirely. Even when residents submit CUP violation reports, we are often told that the CUP language is too vague to hold the company accountable. If the permit language is so open to interpretation that it cannot be enforced, then that represents a serious failure in how the permit was written and approved in the first place. If the county's code enforcement department is already overwhelmed and unable to adequately monitor existing permits, then serious questions need to be asked about whether additional conditional use permits should be issued at all until the county has the capacity to properly enforce them. At what point does the county acknowledge that issuing permits without the ability to enforce them puts the residents at risk? My neighbors and I have spent years trying to work with the county to find solutions. We continue to show up, provide documentation, and ask for help, yet we have seen little action return. Residents should not have to fight this hard to simply ensure their water is safe to drink and that the rules established by the county are actually enforced.
Thank you. Do we have anybody else who'd like to speak on the matter? Anybody online? Guess not. So from here, do we decide whether we can take this up in 2 weeks?
I would strongly recommend against taking it up in 2 weeks. There's kind of a lot to cover here. The I want to try to kind of clear some statements here. So Knife River, they have two conditional use permits. They have one for the Woodward site. They have one for the Veneer site. The one for the Veneer site is not active yet. Everything is on hold. Groundwater is under the jurisdiction of DEQ. Dogami is under controls their operations. The county has been working on this, for years. And so I want to step back for a second and say that to all the neighbors, I hope you guys understand that I feel your plight. I know you guys are sick of hearing that. I want to thank Robin for Central Oregon Land Watch for coming out here and taking this bold action. This is a matter that is very important to me, and I've spent a ton of time working on this. I don't think it's accurate to say that the county has had a lack of action. We have, there is currently, through Dogami and DEQ, there have been tests around the neighbors. Knife River is currently undergoing testing pursuant to Dogami. A lot of these were at the insistence and the letter writing of the county. The Dogami's representation that they may be in violation of the CUP was after a letter that I wrote Dogami requesting an interpretation. The statements that the code enforcement is due to a lack of resources is partially accurate. It's also a decision by county leadership, the Board of Commissioners, for us to be a code complaint driven county. We have the same rules that apply to anybody with a property right. So if your neighbor is doing something wrong, it's the same rules that apply to someone with a conditional use permit. We seek voluntary compliance. So if someone's out of compliance, the way our rules are written, the way we are directed to approach these by the Board of Commissioners is to try to work with the applicant, or not the applicant, with the permit holder in a manner that resolves the issue without having fines come into play. For Knife River in particular, since I've taken this role as community development director, there's a separate provision for aggregate resources, for aggregate CUPs that allows a different enforcement mechanism, which I have utilized, which we have just within the last month received payment from DEQ for established violations for operating outside of operating hours. This is a very complicated and nuanced issue. Initiating a modification proceeding is another complicated issue. The applicant, the property right holder, the CUP holder has property rights. They're entitled to due process. We have a mechanism in Crook County Code 18-172-100 for a revocation or modification of a permit. That is, I'll just read subsection 1. This is kind of the most important one to get it started. So the hearing authority, which would be you guys, it could also be the Board of Commissioners, it could also be a hearings officer. The hearing authority may revoke or modify any permit granted under the provisions of this title on any one or more of the following grounds. The grounds include fraud, concealment, or misrepresentation. The use is not being exercised within the time limit. That one's not relevant. There are a couple other ones here. The permit granted is being recently has been exercised contrary to the terms or conditions of such approval. And so I think I'm familiar with maybe I've been organized for a long time. I'm familiar with the complaints of the neighbors and the opinions that Knife River is operating outside their conditional use permit. Again, it's a complicated and nuanced issue. And so I fully support, if you guys feel it's appropriate to do this initiation. It is completely within your authority. It's within the Board of Commissioners' authority. I would not do it without being properly advised. And so whenever these get kicked off, if they're going to get kicked off, the hearing authority is to notice all the relevant parties, again, due process. And so my recommendation here would be to allow staff to provide a recommendation to you guys. You guys can make an informed decision. And at that point, if you decide to initiate the proceedings, then we would then issue out notice and it'd be a hearing like anything else. For these, the burden is on the county to establish that the modification or revocation is warranted. And so in the spirit of cooperation, since Central Oregon Land Watch is requesting this, I would hope that if we do initiate that proceeding, they would show up at those hearings and provide what evidence and arguments that they can. I would suggest the same of the neighbors. If we go down that path, then it shouldn't just be the county alone, right? Central Oregon Land Watch wants it, they should come help argue the case. But things are moving. I know that there is also funding through the federal government. I forget if it's over $1 million to do a basin-wide study. So stepping back, the DEQ and Dogami's water testing plan ending at the end of this year. I forget. It's going on for a while. The broader federal study I don't know when that's going to kick off, but that will go on for a while. Knife River's testing is going on for a while. Again, veneer is not going to be operational for the foreseeable future. On the Woodward CUP, my understanding is they have depleted the aggregate there. They were washing rock. I don't know are they still? I've been told that they may have a different approach, at least in the near term. But this is certainly on my radar. It's certainly something I've spent a ton of time on, and I fully support Central Oregon Land Watch request and the concerns of the citizens, if warranted. So, like I said, my recommendation would be for staff to go and put together a report to consider where Knife River is with their operations, to consider the CUP and the language and the I guess justification for revoking or modifying that permit in a manner that is in the best interest of the citizens of Crook County. So this is not something we should act hastily on. I understand that we are far enough in the process where hasty maybe not be a word that the neighbors want to hear, but this is a process that has a lot of moving parts, that has been ongoing. But it does make sense, if it makes sense to you as the commissioners in your authority, to bring this to the forefront to get a decision one way or the other. So again, my recommendation would be for staff to bring a report. I think bringing that report in the next 2 weeks might be too short. I want to make sure that the report is substantial and provides you guys with all the information that you need, so you guys can make, like I said, an informed decision on whether to go up or down.
Yeah, are we able to discuss about this, or would you like us to vote?
You wouldn't need to vote now. So like I said, we'd be you guys would be making your decision once I bring you the report.
Okay.
But you guys can certainly discuss it. Think that that's a valid use of staff time. My personal opinion is that would be a justified, useful time of staff resources.
Okay. Yep.
I just want to say that yes, there was funding from the state, that the county wrote letters to the state to get funding to help with this. That funding paid for 2 rounds of water tests in our area, one in the fall, one in the spring. Those test results came back bad. Still nothing happened on the county's end. The funding that's coming is federal money that will not be available until probably fall at best this year. In the meantime, they are still allowed to operate if they wish, when they want to. And you can look at all our test results if you would like, and you can see that they are slowly getting worse. So the request is to stop this before they keep getting worse, not just keep throwing money at it to show that the water is bad.
Julie, I know that you know that those DEQ tests were not to establish causation. They were to inform of health concerns.
Sure. It's a health concern, though, is what I'm saying. It's a health concern, and we haven't.
I'm on the same page as you, but
we haven't found the cause. So let's wait. Let's stop doing when it changed, what changed it, and figure out if that is the problem before we keep going.
Got it. Yeah.
So.
Thank you. So from here, do we like to move on the consent agenda, or do you want us to figure out
I'd like to say something.
Yeah, you
as a commissioner. So I grew up where these folks are talking, and I seen Knife River come in there, and I seen the water go bad. And what people don't get is where the mine is, it's river rock. Okay. So you can actually take, let's say, a truckload of cow manure, and you can dump it on the river rock. And by the time it filters all the way through, you can drink it at the bottom. And so what our county allowed Knife River to do is come in there and completely mine out all of the filters. So these people have low wells. They're shallow wells. So now all the toxins, not really maybe even being Knife River's fault, but anything that filters in that whole valley goes into these folks as well. And I've seen these people's toilets. I've seen it with my own eyes. I watched it all happen, and these people need help. And this is what is so frustrating about our county is we want to continue to kick the can or postpone this instead of just taking care of it, because we're going to set ourselves up for a major lawsuit. And it's either Knife River sues us, the state sues us. In my opinion, we need to help our citizens. They got our backs. Not Knife River. Knife River is a corporation. It's a publicly traded company. They don't give a shit if we have a poisoned well or if we have people die, their bottom line is on that stock market right there, not our county citizens. We need to step up and take care of these people. Do something for them. This is real passionate to me because I watched the whole thing unfold and people are just, especially from, I feel like our county, we just don't want to accept responsibility. We made a mistake by giving that CUP permit out. We never should have did that. Now let's step up and try to help these people and do some damage control. That's my personal opinion.
This won't be popular, Commissioner, but I would suggest that statements, no prejudgment. I suggest that you withhold forming a judgment until you see the staff recommendation, until you see the evidence, and at that point you make your decision up or down. Again, this is not an easy issue. It is fraught with procedural peril, and so it's important that you guys as commissioners, as your responsibility, your authority, you do things the right way. You treat every party even-handedly. You act on the evidence and our code. That's how things can be upheld. Otherwise, they can go to LUBA. They can be appealed for whatever reason. And the best efforts of the Planning Commission would be for naught if you guys don't follow proper procedure.
Thank you. Well, that's my procedure, John. That's how we do it here in Prineville. And I'm sorry, but I've had dealings with Knife River and they have not been, they're dishonest and they've lied to me to my face and they think they're better than all us. And so if I have to step aside from it because I feel that way, I will, but I'm not going to not tell you how I feel.
Kirk, I appreciate how passionate you are on this, and I would like to get more information on this and see it and go through the proper steps. I mean, I think you're absolutely right. It's for the people. We're here for the people, and we should move towards that. And would anybody else have comments on it?
I agree with that thought process. Commissioner Dill, I do agree with that thought process.
Click the button.
Are we here now?
There we go.
There we go. Okay. Marlo Dill. Commissioner Newharth, I do agree with that thought process that we need to use the resources to bring to light what is on file for the Woodward pit so that we can review that.
Yeah, I would, same thing here. I think we need to get it in front of our commission and put the data forth so that we can conclude what needs to happen going forward from this commission.
So I do have a question. How does the Vernier permit, or does it tie into this at all?
That's a good question.
You had to ask that, didn't you? So, very complicated. So here at the county level, they have a separate CUP for Woodward and a separate CUP for Vernier. Through Dogami's operating permit, this is considered one operation. So it's one permit that would cover both properties. Things got held up with them in the application to modify it with Dogami to extend over to Vernier. It's also, they can operate on Vernier through their conditional use permit until they execute what's called a groundwater guarantee, which would protect the neighbors for situations like this. That hasn't been executed, and so that's a precondition on them being able to go into Vernier. The Vernier side is also still stopped because of this current testing by Dogami and DEQ for the groundwater on Knife River site, and so things are currently mothballed on Vernier. There is further complications because my memory on the Vernier CUP is that they would use the settling ponds on Woodward to wash the rock from Vernier should they ever start mining that site. So even though they're separate CUPs, those settling ponds are connected from the Woodward CUP and the Vernier CUP. And those are issues that would need to be sorted out in my staff report to you guys on how you approach this, because if you're going to try to do something with the Vernier permit, that would also need to be part of this modification proceeding, and that might be a separate consideration than doing the same for the Woodward site. So hopefully that made sense. Like I said, it's a complicated issue, but I plan on informing you guys as well as I can.
So I would just join the other commissioners saying that we should be directing staff to look at the process, provide us some direction, put together whatever reports are needed.
Is this something we make a motion for?
First, I want to say one thing.
Sorry.
George, you and I were the only ones on the commission when this whole thing happened. You were there also.
I don't think I was here for the Woodard pit. I was here for the
Veneer?
Yes.
Well, anyway, you remember what it was like.
Oh, yeah.
don't you? Anyway, would you like a motion to direct staff to prepare a report for the commission?
I would.
I would like to make that motion.
That's second.
A motion has been made by Commissioner Steck and seconded by Commissioner Kurtz to approve the allowing the Woodward pit be pushed forward to a future date in mind by staff. Okay.
People from somewhere else.
We have to come up to the mic, yeah.
Yeah. Adam Mikulski, Stahansik Lane. Just a couple of things we're talking about a lot of things about water testing. In the CUP, the original one on Woodward, it was in the CUP that they would not dewater. It's just not a DEQ problem. It's a CUP problem. Also in the CUP, it was stated in there that if they were going to dewater, that they would actually go around to the neighboring wells and develop a testing plan to get a baseline, which they failed to do and stuff. So it's really important that everybody knows that in the public, that when they choose not to follow it, I don't care if they did it on purpose or accident, it doesn't really matter. We write the CUPs, we need to follow it. But I think when you tie it to veneer, and I know George was on veneer, you were on both of them. What's really important is veneer and anything in the future, because these companies aren't going to leave this area if they've got this good rock and sand. They're going to keep pushing. What's really important is to write the other CUPs or the new CUPs or veneer CUP and change it, because it isn't as stringent as Woodward's was. And so as county commissioners, if I was one, it is like, I think it's really important. We need to work on a CUP. We can't have a hearing and people from the public say, we need to do this, we need to do that. Commissioners are from different areas, different expertise. It's hard to write a CUP unless you're experienced in this and know what you're doing. And I think anything in the future, or even what we're dealing with right now, get some professional help to see what actually is out there that can help with that, so we can write a really good CUP so everybody can get along. Either Knife River can get their things done, but we can get we get protected. But all I ever hear is mitigation. Well, you know what? There is no mitigation for dust. The wind blows, it's gone. So anyway, I just wanted the water testing was really important. It was not done. It was in the CUP. It was for DEQ. It just didn't get done because nobody's taking it serious from the other side.
Thank you. No, we really appreciate it. Yeah.
One final response to that. Thank you, Adam. I appreciate you bringing that up. Genuinely.
I really appreciate John. I mean, I work well. I'm not saying he didn't do his job, all this stuff. I'm just telling you what's out there and what has not happened. I appreciate John because I think, and I'm going to say it in public, I think out of the 3 we've had here in the planning commission, I think he's the best so far.
I push back against that, but thank you, Adam. I appreciate that. That is true. I'm more comfortable these days. So we would not have known about the DEQ violation were it not for these attentive neighbors bringing that to our attention. At that point, there was not the communication between the relevant state agencies like there is now. As soon as we found that out, I had communications with DEQ and Dogami, where anything that happens from now on, we are all on the same page and we get notified of that. Moving forward, if such a thing were to happen, we would immediately issue a violation notice and enforce on our side. As for the CUP solving these aggregate mines, I don't think that is the only solution. I think what's more important is our code language. Our code language was put in place through an enforcement order by DLCD in the 1990s because we were denying too many aggregate applications. My understanding is these days, approximately 90% of the aggregate in Central Oregon is produced from Crook County. I know we might have some geographical advantages, but I don't know if that's all of it. I'm sure Adam knows, I wrote a request to DLCD so we could update our Goal 5 program. Part of that is updating our code for aggregate to make sure that we have proper rules in place so these things do operate safely and responsibly. We are still working out the language of that DLCD grant, but as you guys know, we are going to implement that Goal 5 update in the next year. It should get done within 18 months. I don't know what the time scale is for the aggregate, but I do encourage any of these interested parties to participate in any public action committees or hearings we have on that to make sure we have our code in place. You guys have a comp plan amendment for an aggregate site coming up in 2 weeks. So you're going to get a great chance to get this in front of you. The way our code is currently written, any issues addressed in the comp plan amendment are basically in stone. And so the CUP is the issue should be addressed during the comprehensive plan process if they can, instead of the CUP process. The CUP process is great for conditions of approval, but like I said, everything about this is complicated and nuanced. I know quite a bit about this, and so it's been a while since you guys had one of these, but you're going to have more in front of you, and this is going to be a topic of discussion for a while. So again, I want to thank the neighbors, and I want to thank Central Oregon Land Watch, and I look forward to moving forward on this.
Thank you.
Can I say one thing in defense?
I think the motion, yeah, we didn't,
Mr. Chair,
I think we do have a motion before itself. Yeah.
More comment?
Mr. Chair,
Yes.
can I say one thing also? We as a commission are bound by, is my mic? Oh, we're bound by what the comprehensive plan says in regard to aggregate sites and what the county code says in regard to conditional use permits. And when someone comes in with an application, they are telling us that they're following this and they're doing that. And we have to believe that's what they're saying. And we have to follow the code. And if they meet the, excuse me, requirements of what their application is saying, we're almost bound to approve it if it meets all of those requirements. And sometimes it doesn't turn out on the ground the way it's supposed to. We have no way of knowing that, like John said, until somebody lets us know. So that's just a word in defense. Sorry.
Thank you. So as George politely reminded me, I think we still have a motion on the floor that we need to call to a vote. So the motion has been made by Commissioner Steck, seconded by Commissioner Monty Kurtz to approve the to approve the Woodward aggregate mine.
To request staff to produce a report on the potential of a modification and revocation proceeding under Crook County Code 18-172-100.
Yes.
You said so moved, but
So moved. Perfect. So we'll call for a vote. Kirk?
Aye.
George?
Aye.
Laquita?
Aye.
Monty?
Aye.
Marlo?
Aye.
Am I? Motion passes unanimously. There we go.
Get to work.
There we go.
already there.
Okay. And for the public, do we have any other public comment? No, we'll move over to the consent agenda. Okay, nothing online? There we go.
Mr. Chair, I move we approve the consent agenda.
I'll second.
Okay. Motion,
One quick question.
Mhm.
Should we signify what that includes the June 25th minutes and the July 2nd minutes of 2025?
Consent agenda.
Does that need to be in the record?
It is written on the agenda, so it's
Okay,
there's no harm.
second.
Okay, so motion has been made by Commissioner Pont and seconded by Commissioner Stack to approve the consent agenda. We'll call for a vote. Kirk?
Abstain.
George?
Aye.
Laquita?
Aye.
Monty?
Aye.
Marlo?
Aye.
And aye. Motion carries. Yeah, unanimously, I guess. If you abstain, I don't know if
It sounds good to me.
sounds good. Okay. Move on to continuation for deliberation. Let's see. We'll now move on to the next item on the agenda, a continuation for deliberation only. Record number 217-25-000-293-PLNG, Alexander Ranch LLC, which is the owner, and Harmony Towers, which is the Verizon applicant, and ACOM Consultant Inc., which is agent of proposing a telecommunication facility. Subject property is located on Southwest Williams Road, north of Highway 126, and is identified as map tax lot number 151 414-0000-100. The hearing is being held pursuant to Crook County Code 18.172. The Planning Commission will be evaluating the request against the following applicable criteria: Crook County Code 18.16, exclusive farm use zones for EFU3, Crook County Code 18.124, supplementary provisions, ORS 215.283, ORS 215.275, and Crook County Comprehensive Plan. Do we have any members that have a conflict of interest or bias to disclose?
No.
No.
You know, has any member of the commission had an ex parte contact with the applicant or any members of the public regarding this matter?
No.
No.
Commissioners should disclose if they visited the site and state on record any observations and impressions from the site. Kirk?
I've drove by it because I've worked in Powell Butte, but I think I've said that, 4 or 5 months ago.
Yeah. Yeah. George?
I have not visited the site.
Laquita?
I have not visited the site.
Lonnie?
I have not visited the site.
Marlo?
I'm familiar with the site, but have not specifically visited the site.
And I have not visited the site. Are there any members of the public in person or participating remotely who wish to challenge any members of the commission? If participating online, please enter a request to speak using the chat feature. Okay. Hearing none, we'll move on. We will now proceed with staff's presentation.
Thank you, Chair Newharth. All right, so as stated a minute ago, I have not been in this position for that long. And so I don't know how unorthodox tonight's going to be, but at the last hearing, we kept the record open for the 777 period. Typically, I would provide you guys with a staff report, which would enable you guys to make a decision as you guys were scheduled to deliberate tonight. With the timeline that we presented, with the complexity of this application, the substantiation of the record, and the competing arguments, it was not reasonable at all for me to be able to give you guys a finalized staff report on the same day that applicants' final arguments were submitted. So tonight, since that wasn't going to be possible, my idea instead was to provide you guys with a draft staff report that I'm going to walk you guys through line by line. And as we do that, the final decision that you guys make as a planning commission with an application as complicated as this, the most important thing is having very solid, very thorough findings, to have your reasoning be on paper, to have it be easy to follow. So you guys have the best possible final decision for any potential reviewing judicial authorities. And so the way I envision tonight, I don't know if this is how planning commissions and counties across the state usually do this, but my idea is to walk you through the staff report line by line. And as we go through this, I want you guys to take notes, to highlight things, to basically consider which arguments you guys find persuasive, which arguments you guys find are not persuasive. I want you guys to note anything that you think is missing, any arguments or facts or issues that I did not address so far. And basically just let us all walk through this at the next, and basically at the end, I would recommend that you guys continue this hearing until 2 weeks from today, so that I can present you guys with a final solid staff report, so then you guys can deliberate with everything you guys need, and you guys can, on the record up there at the podium, explain your reasoning on why you went which direction you went. So then I can produce a final decision to be signed out of a meeting that will be the best document that we can have to reflect the consideration you guys gave this application. Does that make sense? Are there any questions about that process? All right. And it's got it up already. So that's, I say again, this is a draft staff report. It's not even a completed draft. I have a lot of obligations as community development director. Got this done as good as I could. With the hearing, it's mostly has most of the things in there, but like I said, as we walk through this, please feel free to stop me. And then feel free to ask as many questions as you'd like to at the end. Like I said, there'll be a final staff report 7 days prior to the next hearing, 2 weeks from now, if you guys make that motion at the end of this. So, all right, Hannah, we're just going to walk through this. It's going to be a fun evening. All right, so, all right. Go down. Procedural background. This part is mostly housekeeping. The application was submitted on August 28th, 2025 and deemed complete on August 1st, 2025. And again, there may be typos and grammatical errors in here. This is, like I said, a rough draft. And so take it easy on me if you find too many of those. Though the Crook County Code directs applications that are subject to standards to be processed as administrative decisions, Community Development Director John Eisler invokes his authority under Crook County Code 18172-015 to refer this application to the Planning Commission. The first evidentiary hearing was noticed for December 17th, 2025. Public notice was posted on the Crook County Public Notices page, the Crook County Planning Commission calendar, November 13th, 2025. Posted in Central Oregonian, November 18th, 2025. Mailed to neighbors within 750 feet of the property boundaries on November 26th, 2025. The initial evidentiary hearing was held on December 17th, 2025 and continued with the record remaining open to a time and date certain of January 14th, 2026. The applicant supplied a letter waiving both state and federal timelines and tolling the relevant timelines to a date of February 27th, 2026. January 14th, 2026 hearing comprised of testimony from the opposition, another shot clock waiver from the applicant out to March 31st, 2026, and a continuation of the hearing until February 11th, 2026. At that February 11th hearing, further testimony and evidence was received. At the conclusion of the hearing, the Planning Commission moved to keep the record open for the submission of new evidence in response to written and oral testimony until February 18th, rebuttal evidence until February 25th, and the applicant's final written argument by March 4th, with the Planning Commission reconvening for deliberations only on March 11th, 2026. The applicant has further told the applicable state and federal decision deadlines to April 28th, 2026. The record is comprised of 222 exhibits. The vast majority are in opposition. Likewise, during the 3 evidentiary hearings, the vast majority of testimony was in opposition. Opposition arguments ranged from highly technical arguments directed at the applicable criteria by opposition experts to arguments outside the scope of the application. Then I'll walk through the findings and it's the beginning part, but scroll down to, keep scrolling down, Hannah, to the Sprint PCS case. Okay, so here's where we begin to kind of get into the meat. Crook County's code incorporates the language from ORS 215-275, which is a codification of McGaw Communications versus Marion County. The controlling case on how to apply ORS 215-275 is the 2003 ruling by the Court of Appeals in Sprint PCS versus Washington County. Both the applicant and opposition have frequently referenced this case with differing interpretations. The ruling had some nuance critical to the decision here, so a detailed explanation is warranted. In that case, Sprint applied for a 154-foot monopole tower with 12 antennas on a parcel in Washington County zoned EFU. Sprint's stated objectives in the application were to, 1, enhance telecommunications service along a section of Highway 219 and the rural areas surrounding that section of highway, and to 2, create space on the tower to lease to other providers. Sprint provided a search ring with 63 potential sites, 26 of which were not zoned EFU. The opposition in that case, the Fritzes, intervened and provided testimony from an engineer who suggested Sprint co-locate on an existing tower and questioned several aspects of Sprint's request, including elevation determinations made by Sprint, tower height, search ring size, and location. The county adopted the findings of the Fritzes' attorney as its own and denied the application. Sprint appealed, Luba remanded, and the Fritzes appealed to the Court of Appeals. On review, among the Fritzes' arguments was that 1, Luba erred by holding there was no need to balance competing interests such as farmland preservation and technological feasibility in determining whether it is necessary to site a utility facility on EFU land. And 2, Luba erred in ruling a county cannot examine reasonable alternatives not contemplated in the applicant's business plan. The Court of Appeals affirmed Luba on the first argument regarding the obligation for a county to balance the need to preserve farmland with competing interests. The Fritzes there argued the terms reasonable alternatives and feasibility in ORS 215-275 should be interpreted in light of the goal of preserving farmland. The court sided with Luba that the provisions of ORS 215-275 strike the balance between the need to site facilities on EFU land and the need to preserve farmland. The court explained that under ORS 215-275, an applicant must show that reasonable alternatives to siting the facility on EFU land were considered, but that because of one of the 6 factors set out in paragraphs 2A through F, it was necessary to site the facility on EFU land. The court continued that the legislature, having identified those 6 factors, the court continued that the legislature, having identified those 6 factors, implicitly precluded consideration of additional factors in deciding when utility facilities must be sited on EFU land, and a county may not import additional policy considerations into their analysis. The Fritz's second argument regarding reasonable alternatives is where we get in the weeds. LUBA had ruled that because co-locating would not satisfy all of Sprint's objectives, it would not satisfy the objective of leasing to other providers, that it was not a reasonable alternative. Further, on appeal, the Fritz's conceded that reasonable alternatives did not require Sprint to consider different methodologies of providing the same service, such as landlines. However, the Fritz's argued LUBA gave too much deference to Sprint's business plan, and merely because the applicant may have a desire to construct a commercial tower on EFU land to maximize profit by selling space on the tower, the county is not obligated under ORS 215-275 to defer to that desire under state land laws. Sprint countered that reasonable alternatives refers only to reasonable alternative sites, and the Fritz's were seeking to convert that phrase into an open-ended invitation to counties and opponents to second-guess complex business decisions and technological decisions, and to require a utility provider to reconsider its fundamental technology or its business plan as a reasonable alternative. To resolve the dispute, the court applied maxims of statutory interpretation to define the phrase reasonable alternatives as used in ORS 215-275 sub 2. Without the assistance of any legislative history, the court was limited to the text and context of the statute. The court considered the cost consideration language in ORS 215-275 sub 3 to conclude that, quote, the obligation to consider reasonable alternatives may include consideration of facilities on non-EFU land that are not substantially similar to the facilities on EFU land. The court then moved to LUBA's holding that gave full deference to Sprint's business plan. The court noted that LUBA did not base its ruling on the text, context, or legislative history of the statute itself, but instead simply concluded that a line must be drawn somewhere, and any other approach would require second-guessing complex business and technological decisions. The Fritz's here argued that LUBA's approach runs the risk of elevating the utility's business goals over the statutory goal of protecting farmland, and more specifically, that only a utility's objectives that advance the goal of providing utility service should be considered. Sprint countered that LUBA's approach appropriately recognized that a utility provider must be allowed to build a facility that meets its service objectives. Court found merit in the arguments of both parties and LUBA's reasoning for the need of a bright line somewhere. The court recognized that the problem lies in articulating a standard that captures the distinction of when an alternative is reasonable versus when it's not. The line that LUBA drew, according to the court, gave too much deference to the utility. Here's the Sprint case's key sentence. When a utility's defined objective is inconsistent with placing a facility on an otherwise reasonable non-EFU site, local governments should ask whether that objective advances the statutory goal of providing the utility service. Applying that sentence to Sprint's stated objective of leasing space to other providers, the court said that a county could find that the goal of maximizing profit by leasing to other carriers does not advance the statutory goal of providing utility service. Or, instead, the county could agree with the utility that building a tower with extra capacity is an efficient and cost-effective way to plan. Either way, such questions present a factual issue for local governments, subject to review by LUBA. As applied to the present application, the Sprint PCS case provides the following guidance in this decision. Number one, the consideration is limited to the factors in ORS 215-275. Number two, alternative sites on non-EFU land that are not substantially similar in cost or methodology may still be appropriate for the county to consider, and whether a utility's stated objective furthers the statutory goal of providing a utility service in light of reasonable alternatives is a factual issue for local governments to sort out. Layering the backdrop of the Sprint case with staff's prior guidance provides an effective means to approach the application. Staff have advised a three-part test to apply ORS 215-275. Number one, do the applicant's defined objectives support the statutory goal of providing utility service? Number two, have reasonable alternatives been considered? Number three, have all of those alternatives been effectively ruled out by one or more of the enumerated factors in ORS 215-275 sub 2?
John, can I ask a question?
Absolutely.
Okay, so with going with what you just stated and with what we'll come to later in their final written argument, they make it pretty clear that Highway 126 is a major part of their goal of improvement. And yet all of the data that we have been provided says otherwise. Like they have their target area, which covers about that much of 126, and it leaves this much of 126 blind. And alternates actually do a better job of covering 126, but not as much to the north. That's just based on alternate 1, 2, 3. Looking at the graphs they gave us.
You're jumping way ahead of me.
Okay.
Commissioner.
All right. But am I on
Yes,
right?
You are. So like with everything
I'll
else,
make sure I'm following.
it's a factual issue for
Okay.
you guys to sort out.
Okay, great. Thank you.
And that's the whole point of this, is for you guys to make those
I just
notes.
want to make sure I'm on the right path.
Yep.
Okay, great.
Yep, detail those facts, if that is the direction that you think that particular aspect leans.
Okay.
All right. So from here, I go to the evidence in the record. So the application. The application requested approval for a telecommunications facility at the subject property based on Verizon's need to increase cellular capacity along Highway 126 between Redmond and Prineville and to expand coverage to the Palo Butte community. The application included, among other submittals, a Verizon wireless radio frequency letter by Tom Ferguson. I'm going to kind of read this as quick as I can. An RF justification letter, drive test report, and alternative site analysis from Bawabco's Consultants, LLC. The Ferguson RF letter analyzed Verizon's 700 and 850 megahertz bands. The letter's objective states that if capacity is not the customer... There's a typo there. Well, it's not the customer experience will degrade. Over the years, Palo Butte customers that live on the north side of Palo Butte have complained about their service as they are in the shadow of our cell coverage, even though they are very close to the site as the hill itself is blocking the signal. The letter continues that the proposed site was identified to provide better service to the Palo Butte community and also offload, excuse me, the existing site's traffic. The 3 existing sites are the McCoyne, Wiley, and Palo Butte South Towers. Ferguson supplied graphs depicting the capacity of those towers with average scheduled eligible users, which was described as one way that Verizon measures the existing capacity in the sector. Took that from the application. The graphs and explanations show that the McCoyne Tower requires offload from the proposed site. Ferguson stated that the proposed site will enable offload in the McCoyne Tower. Wiley has plenty of capacity and is in, quote, good shape, as that tower was not a driver for the proposed site. And the PBS tower is exhausted at times during the summer months, which will increase until there is an additional tower to offload. The Ferguson RF letter also included a few maps depicting an area of shadow coverage south of Highway 126 that the proposed tower sought to alleviate. Ferguson's Verizon data was used to inform the Bawabco's RF design analysis. The analysis lists the capacity objectives of the new site as 1, providing additional bandwidth for customers in the area surrounding the proposed site, 2, providing better throughput for indoor users in the area, and 3, offloading sites to the west and south that are over capacity. Regarding coverage objectives, the analysis lists the rural area north of Highway 126 and along Southwest Williams Road and feeder roads. As for why the proposed location, the analysis states a lack of quality services in the surrounding area for all 3 carriers, significant growth in wireless utilization in rural Oregon, and that the sites to the south are over capacity. The alternative site analysis provided a focus zone with 5 alternate locations for towers, as well as consideration of the 2 existing Verizon towers in the area. The applicant provided maps of RSRP coverage at 180 feet above ground level at the low bands of each alternate site and ruled out each site on the following grounds. I'll kind of run through this quickly. Alternate site 1 is the Sprint ATC tower, 196-foot lattice tower. It's 4.28 miles southeast of the project site. The applicant states this site will not achieve the coverage or capacity objectives as it provides reduced coverage compared to the subject property and does not provide the offload to the neighbors to the east and south. The Verizon wireless tower at Wiley. This tower already has Verizon wireless antennas, adding more according to the alternative site analysis prepared by the applicant's consultant. This tower will not provide the power per link or throughput per link needed to resolve the issue. Down to the Palo Butte South Tower. southwest of the project site already has Verizon wireless antennas like the Wiley Tower. According to the alternative site analysis, adding additional antennas to this tower will not provide the power per link or the throughput per link needed to resolve the issue. Alternative site 1 is in the PBR 20 zone. The analysis states that location provides reduced coverage compared to the subject property and is situated too close to neighbor sites to the south and will not provide the service needed to the north. Alternate site 3 in our R5 zone in the northwest. The analysis states that site is too far north. Will not provide the offloaded neighbor sites to the south and provides less coverage than the subject property. Alternate site number 4 is also R5. So the analysis there found this site unsuitable because it is too near existing facilities and will not provide the needed service to the north, has reduced coverage, and does not fulfill the project's technical requirements. Site number 5, rural service center zone to the south. Like other southern alternative sites, the analysis concludes this location does not provide the needed service to the north and has inferior coverage. The application also included a drive test report performed July 4th, 2025. The drive test involves active call testing with 3 phones, one each for Verizon, AT&T, and T-Mobile. The drive test evaluated both low band and mid band as shown below. The drive test concluded that existing sites do not provide the level of service needed in the area as there is a lack of quality throughput all the way down to 500 kilobytes per second. The conclusion also states that existing sites are over capacity and need offload from a new site and that other carriers are in a similar situation and would likely co-locate with the proposed site. Part 3, the initial evidentiary hearing on December 7th or 17th. The applicant presented these materials at the initial evidentiary hearing on December 17th, 2025 through presentation exhibits 180 through 183. Stephen Kennedy of Bawabco's Consulting provided an overview of the technical material. Kennedy noted that the subject property was a capacity site and that the primary objective was to provide coverage and offload the surrounding area for capacity. Kennedy said that coverage is generally good, but the new tower will provide better coverage for indoor users. Opposition also provided testimony at the December 17th, 2025 hearing. In particular, Annette, the PhD in physics, gave testimony supporting exhibits 178 and 179 from her and Karen Jones, and including technical analyses from Stephen Mahan and Michael Scheinfein, collectively referred to. You guys were the objectors, not the opposition. You were the objectors to fix that. Colosi presented numerous arguments against the application, many of which were addressed in staff's January 7th, 2026 supplemental memo, fully incorporated into these findings. And so both of the memos that I wrote to you, I incorporated those instead of pasting them in here. And so I would ask that you also review those, try to find aspects or facts or whatever in there that is relevant to your decision-making process, and bring those forward to the next hearing. If you guys need copies of those staff reports and memos, I can give those to you. Among the opposition's arguments was that the applicant had not provided a consistent search ring, and to achieve the stated objectives, the search ring should be further south. You can see in that graphic there. Opposition also provided additional alternative sites A through I for the applicant to consider. Evaluation of those alternatives, as well as opposition's other arguments, will be addressed below. Continued hearing on January 14th. The December 17th, 2025 hearing was continued to January 14th. At that hearing, the applicant did not have new materials ready to present. Numerous parties in opposition testified and submitted evidence as detailed in staff's February 5th, 2026 second supplemental memo, fully incorporated into these findings. Of particular note, opposition consultant Michael Scheinfein presented a technical critique of the application. Scheinfein's conclusion was that there are numerous options using alternate sites that are technically feasible to meet the coverage and capacity objectives identified by the applicants. Regarding capacity, Scheinfein leaned on the statement in the Ferguson RF letter that the whole area would be fine if not for the south side of Powell Butte between Brasada Ranch and the proposed site. Each of the alternate sites 2 through 5 would provide better offload than the proposed site, according to Scheinfein, which would enable the Wiley Tower to be turned down to the north so it could provide more capacity to the south. Regarding coverage, Scheinfein lamented that the underlying data was not provided, yet alternate sites 1 through 4 would provide reasonable coverage over the 4 problem areas or pinch points as compared to the proposed site. Scheinfein also addressed the reasoning by the applicant to eliminate the alternative sites, arguing that the coverage from the alternate sites would be just as good as the proposed site. Verizon has many towers in the region with close spacing, and offload from the Wiley and PBS towers could be accomplished with these alternate sites. The continued hearing at February 11th. The hearing was continued February 11th. Prior to that hearing, the applicant submitted exhibits 207, 208, and 211. Exhibit 207 included legal arguments and addressed procedural and non-ORS 215-275 issues raised by opponents, which will be covered below. Exhibit 208 is a new alternate site analysis by Boabkos. Exhibit 211 was a newly prepared RF report by Verizon's Tom Ferguson. The new RF report at Exhibit 211 is very important as it changes certain aspects of the application. Ferguson states the new RF report expands on the original study. This RF report describes a long-term plan to down-tilt the three major existing towers, McCoyne, Wiley, and PBS, for multiple shorter towers with high capacity and lower coverage, with the goal of reducing overlap and interference. By demonstration, the new RF report mentions the existing Wiley Tower and its significant height in excess of 2,000 feet being, quote, beneficial for initial network deployment, but becoming a liability as adjacent sites are constructed. Thus, as more towers are constructed in the area, there will be a greater level of interference, so the plan is to down-tilt Wiley to reduce the geographic coverage area and improve capacity within its service area. Specifically, the report suggests down-tilting Wiley away from Highway 126 in Palo Butte, as well as the west side of Prineville near the airport. This plan requires a tower at the subject property and an additional new tower near the airport. The report also explains that since the original RF report, Verizon has already optimized the McCoyne Tower by changing the antenna azimuth and increasing the down tilt, successfully reducing its coverage away from the proposed location. Whereas at the time of application in the original RF report, it was the Wiley Tower that had ample capacity. It is now exhibiting signs of exhaustion during the peak summer months. McCoyne now has ample capacity as it is no longer serving the Palo Butte area, representing a good example of what happens when a site uses down tilt to remove service area / traffic. The graph there. A third major change in the new RF report is the inclusion of a new official search ring. Ferguson describes the new search ring as roughly the area that could provide the coverage plus spread out the traffic among the three stand sectors that Verizon utilizes. The specific location is needed, according to Ferguson, in order to eliminate the overlap between the Wiley and PBS towers. The new RF report concludes that the proposed site will allow for the down tilting of the PBS tower to reduce its coverage footprint. Wiley will be down tilted upon the installation of the additional new tower near the airport, and then ultimately Verizon will require the existing leased ATC Sprint tower to fully offload the Wiley sector. Exhibit 208 is the new alternate site analysis by Kennedy from Boabkos. This new analysis utilizes the search ring and coverage objectives supplied by Ferguson in the new RF report. The analysis includes RSRP maps in the low band 751 megahertz range and drive test maps at the 2100 megahertz. Additionally, the analysis considers each of the alternative sites. One by one, the analysis eliminates each of the alternatives, like this example for alternate site 4. The conclusions from the analysis are as follows. The American Tower site to the east is farther away from the target area and will not satisfy the coverage objective for this site or adequately offload the overloaded sites. Of the 14 alternates reviewed, 2 are not available because of EFU zoning and HOA prohibitions. None of the 12 remaining alternatives achieve the coverage requirements as well as the proposed site. None of the alternatives are feasible to provide the coverage and offload capacity service needed. And then it concluded by recommending approval of the proposed site as the alternate sites do not satisfy the coverage and capacity objectives for the site. The new material from the applicant was presented at the final evidentiary hearing at February 11, 2026. At the hearing, Kennedy described the 3 main towers, McCoyne, Wiley, and PBS, as boomer towers, and explained that such towers worked fine until the digital era, with service now increasingly provided by shorter towers. Kennedy explained it as a low-band capacity problem, alleviated with more mid-band capacity and coverage. Kennedy walked the Planning Commission through Exhibits 211 and 208. At the end of his presentation, Commissioner Dill asked Kennedy when the 2100 megahertz band became the goal or standard to achieve. Kennedy responded that basically because there's so many users out there and there's limited bandwidth, limited spectrum that the FCC allocates for carriers in the lower bands, and it's narrow. So the 751 megahertz channel is a 10 megahertz channel, so it's limited. It's a smaller water pipe, and it's low band. It propagates farther than mid-band. That's great. Well, now we're overloaded. At the mid-band, instead of 10 megahertz, it can be 30 to 40 megahertz wide, so that water pipe is a whole lot bigger. So we go and do the offload at the low band, great. But we add in the mid-band, and all of a sudden, all that utilization is happening because, like I said, these guys are running 24 hours a day. As long as they're on, they're talking to a network. That's what the midband does. And 90% of the spectrum that all wireless carriers own is midband or above. Kennedy continued that there may be auctions from the big beautiful bill coming up in the next few years in the spectrum bands around 3,500 to 5,300 megahertz at even higher frequencies in very small areas. Low-band spectrum is highly sought after, and there's very little of it left. Pro Tem Commissioner Kurtz asked Kennedy about alternate site number 2 near Twin Lakes. Kennedy responded that the site was limited to 50 feet and will not provide the same level of service as it is in the southwest side of the coverage objective. Kurtz then brought up alternate sites 1 and 2 and said that it looks like they both provide better coverage along Highway 126 to be the biggest gain. Kennedy responded that a tower would be limited to 50 feet. Kurtz brought up the idea of a new tower and a co-located space on alternate site 1, the Sprint Tower. Kennedy brought back the primary coverage objective and the need to provide coverage to the north. Kurtz responded that there's nothing up there. It's all desert and farmland. Kennedy replied, farther north outside the primary coverage objective possibly, but in the primary coverage objective area, there is utilization going on. Commissioner Warren brought up the numerous comments from opposition that their service was fine and asked where the threshold is to know when there's a need. Kennedy responded with the capacity charts from Ferguson's Exhibit 211 and how the engineers need to look at the ASEU capacity limit and the need to plan years in advance. Commissioner Dill then asked if the airport creates interference. Kennedy responded that the airport uses a different spectrum or frequency band. The interference that Kennedy has been referring to is from boomer towers that are very tall and pointed at each other. That's the spectrum noise we're talking about that becomes a problem because a site covers too far, so we have to bring it back, just like you did with McCoyne. We brought it back. We down-tilted it. Great. It's not providing the same level of noise it was doing before, but now where did those users go? They went to Wiley, and Wiley has to pick up slack. Next at the February 11th hearing was opposition parties. Annette was the first to testify, referencing her submitted Exhibit 213. After addressing some of Kennedy's comments, urging the Planning Commission to require the applicant to play by the rules and pointing out that any of the alternate sites could provide equivalent emergency service coverage, she raised issues with the new alternate site analysis. She began with alternate sites 3 and G, which Kennedy initially said in July 2025 were not a feasible alternative, but now says they would work, but for the CC&Rs and zoning restrictions. She then showed the CC&Rs presented by the applicant were not for Crook County's Twin Lakes subdivision, but for one in Virginia. She noted, according to the ASA, if alternate site 3 can be cited despite the CC&Rs, it's game over. She then took issue with the applicant's new search ring. After we pointed out that Verizon, quote, after we pointed out that Verizon didn't have an appropriate search ring, they made one. They drew a ring around 36 tax lots around the proposed site. And that's the site that they say you have to put a tower on to make this all work. Saying you can draw a ring around the EFU lot that you want to use for your cell tower is simply a perversion of the Sprint case and all the cases that talk about how this process works. The problem with such a ring, she says, is that that's not the only tower the applicant is planning, warning a ruling here would bind the county forever. She then makes note of the engineer's seal on the RF analysis. She points out the engineer is from North Carolina, licensed in every state, and his, gotta fix that sentence, his specialty was like various different aspects of what he does. Her point was that the seal does not change the substance of the evidence and the record or the credibility of the experts. She concludes with a plea to preserve the character and unique agricultural community of Powell Butte against the tide of development. She notes the citizens are doing everything they can, but it's up to the Planning Commission to make sure developers play by the rules. I want to note here there were, like I said, this is not a finished product. There was other testimony provided that I didn't have listed here because it's short on time, and so I just did the ones that are in here, but in the final staff report, it will include everybody, just so you guys know. Next up at the hearing was Michael Scheinfein. Scheinfein began by asking the commission to remember Mr. Connor's statement that, quote, everyone wants to limit the number of towers and how the evidence from the application contradicts that. Scheinfein noted the tremendous control Verizon has over a system as a whole, repeating Kennedy's statement that it's a game of dominoes and that there are myriad potential solutions. Scheinfein then pointed out that other than the drive data, there are no coverage or capacity discussions for the midband. Next, Scheinfein addressed his credibility. The application comes down to positioning and building antennas, and that's electromagnetic wave propagation. And that governs how all this works. Frequency bands are specified. Interference is based on based on just standard issues in electromagnetic theory, which I taught to graduate students for 15 years. So these are the guys that go out and get jobs building these things. Of course, I know how these things work, and so it is absolutely suitable for me to make comments about this. Likewise, they impugn Mr. Mahan's credentials. Mr. Mahan actually designed silicone for the handsets for phones. You can design silicone, you can't design silicone for phones unless you know how they work and how they talk to the network. He absolutely knows how they work. I think keeping the playing field level is kind of important. Scheinfein continued that his role is to provide clarity and context to the data. Scheinfein's first slide was the original capacity report from Ferguson, where the Wiley Tower had plenty of capacity. Scheinfein then moved to the new Ferguson report and the items that troubled him. In the new report, Verizon has already tweaked the McCoy Tower and modified the network. So any data contained in the first packet can't be relevant anymore because all of the coverage and capacity that used to go to McCoy is gone. All of that data is now irrelevant. The part that concerns Scheinfein the most about the integrity of the data is the spike on the Wiley Tower just before McCoy was turned down, noting, quote, something is not right here. Scheinfein then turns to the two RSP 751 megahertz coverage maps from April 17th and December 31st. How could this map reflect the reality if it doesn't change in the north sector because McCoy doesn't cover it anymore? And it isn't. Scheinfein lamented that he doesn't know why because he does not have access to the underlying data, so he cannot tell if it's a mistake or intentional. Scheinfein then turned to the drive data, drawing attention to the north part that had previously been covered by McCoy. The new drive data, dated 2026, cannot be accurate anymore or substantiated as it's the same as prior to McCoy being turned down. Scheinfein then discussed Verizon's long-term plans. McCoy has been turned down, and Ferguson's new report states Wiley will also be turned down, taking another leg away. Scheinfein said as you start turning these things off and having short towers instead of tall towers, there's repercussions from that. As you start turning the tall towers off, that means the only way to provide coverage in these areas is to populate it with low towers that are closely spaced. Scheinfein stated there are many other ways to solve this problem, and the applicant has presupposed the solution here. They have presupposed that they're going to turn down these long-range towers and fill the area with smaller towers. Verizon's plans, said Scheinfein, represent a grand change to the network in your area. Scheinfein equated the Ferguson report to a tell in poker and disputed the applicant's statement that there is no tentative plan for future tower development in the county. Next, Scheinfein moved to the new alternate sites analysis, referring to it as the gory part. Scheinfein brought attention to the table at the top right of each alternate site analysis, which show the proposed site as fabulous, and 10 of the 14 alternate sites having nearly identical numbers with no effect at all on the system. Scheinfein singled out alternative D, which is less than a mile from the proposed site, and shows zero offload, which is, quote, inconceivable. Scheinfein's final point was to focus on the total height and elevation, not simply the height of a specific tower. And then we moved to the open record period. We're over halfway done. Following the February 11th hearing, additional exhibits were submitted during the open record period. Exhibit 215 is from opposition parties, Colosi and Jones. Their expert Scheinfein and Mahan. Their first portion of Exhibit 215 is from Colosi. There she makes the non-technical points that applicant is overstating the deference due to a utility from the Sprint case. The Twin Lakes HOA does not necessarily prevent the siting of alternate sites 2 and G, and questions whether there are FCC rules applicable to Verizon's turning down of the McCoy Tower and plans to do the same to Wiley and Palo Butte South towers. She then questions why the applicant did not consider taller towers, shorter towers, or multiple towers outside EFU zones. She also brought attention to the reference to several other existing or past Verizon leases mentioned in the new Ferguson report, and if those locations would work for a co-located antenna. The remainder of Exhibit 215 is from Scheinfein and Mahone. First, they note that every coverage map on the record represents only low-band frequencies, yet the applicants keep referring to the need as a mid-band problem. As to why, Scheinfein and Mahone speculate that the maps depicting the mid-band range would demonstrate that multiple additional towers would be necessary and additional alternatives, such as fiber optic, would then be reasonable. Next, they note that Ferguson's report shows the need for 3 new sites total, with more undisclosed, contradicting the applicant's representation that it has no tentative plans for future towers. They then address the 2 capacity graphs in the old and new Ferguson reports, particularly the change in capacity limits for the Wiley Tower. As the 2 charts overlap over time, the change that appears in the Wiley capacity limit is likely arbitrary and intended to justify the need for a tower at the proposed location. Next, Scheinfein points out that the matching coverage maps from Ferguson on April 7th and the Kennedy on December 31st. Because Kennedy's map was developed after McCoy had been turned down, the calculations must be different and the map must look different, so the new map cannot be correct. Then asserts that the same is true for the two matching drive test maps. Moving to the alternate site analysis, they conclude that the data is likely inaccurate in that it shows 10 of the 14 alternate sites with almost no effect, particularly alternate sites C and D, which are very near the coverage objective area. Further, they say that the alternate site analysis should have been performed with maps representing the anticipated future network configuration. Instead, they assert as the maps are best server plot maps with Wiley and PBS operating fully, the effect of the alternate sites is understated. This is shown by alternates 3 and G looking better than the others because they are furthest from the boomer towers. Were the test run in its to-be-operated configuration, each alternate site would then become a best server and the proper coverage would appear on the maps. They then address Kennedy's statements that a new tower must be within the coverage objective area or it can only serve one sector at a time. That statement is not technically supported, they assert. Additionally, with the numerous errors identified by them in Kennedy's original maps, it is, quote, evident that numerous other errors still persist, making the current alternate site analysis unconvincing at best or erroneous at worst. On page 24 of Exhibit 215, they note the contradictory and changing story of the ATC Sprint Tower. First, Kennedy stated that tower is unable to relieve capacity at the Wiley Tower, while Ferguson said the same tower will be needed in the future to, quote, fully offload the Wiley sector. Second, Mr. Kennedy stated that ATC Sprint Tower is too tall and that it will create interference, but there is no consideration to putting an antenna lower on that tower. Finally, the Kennedy map at Exhibit 207, page 60, contradicts with the original Ferguson map showing coverage from one of the lobes on the ATC Sprint Tower. John Fine's concluding statement is, quote, Verizon repeats in the new Ferguson report they intend to turn down the Wiley and Powell Butte South towers as they did the McCoy Tower. If Verizon is allowed to go forward with its plan to turn down or turn off the towers that are currently serving Powell Butte, quote, just fine, the only technical alternative would be to fulfill Verizon's stated plans is to replace the coverage of McCoy, Wiley, and Powell Butte, in addition to the 3 new towers Verizon has identified. Exhibit 211. If the county finds there are no non-EFU alternatives that work for Verizon's, quote, anticipated network evolution in this case, how could it find for future applications that there is feasible non-EFU land for a tower site? The proliferation of towers will be unstoppable. The next new record in the exhibit is Exhibit 216 from the applicant. The exhibit includes a letter from Ferguson, a letter from Kennedy, a new alternate site analysis slides for alternate sites 2A and 5A, copy of the Twin Lakes CCNRs, a statement from the title company that the applicant, a statement that a title company has made the applicant uncertain if said CCNRs would apply to a tower, thus the applicant is no longer considering the CCRs an impediment, a copy of sections of the Crook County Code, a copy of Harmony Tower's procedures for complying with federal bird laws, and a copy of a timeline waiver out to April 28, 2026. Ferguson's letter addresses 4 points. First, he speaks to the McCoy optimization, stating that Verizon had plans to do so even before filing the application because of capacity constraints. With the current capacity needs, either Wiley or McCoy would be overloaded regardless, thus demonstrating the need for a new tower. Ferguson also said that the maps did not change after McCoy was turned down because the maps show coverage, not capacity, and coverage loss from McCoy was picked up by Wiley. Next, Ferguson addressed the allegations that a motive for a new tower is to lease to other carriers. To that, he responded that the sole need for this proposed WCF site is to address Verizon's capacity and coverage issues in the Powell Butte area, that Harmony Towers was hired to find a suitable site, and, quote, since there are no co-location options in this area, we determined that a new WCF tower is necessary to resolve Verizon's capacity and coverage issues. The third issue addressed by Ferguson is the search ring, which objectors say is relatively small and located in the area of the proposed site. Ferguson explains he does not know why that search ring was not submitted earlier, as he was not the RF engineer who initiated the project, but given the relatively flat terrain of the area, the search ring needed to be centered within the coverage area. The coverage area, in turn, was selected to handle the handoff from McCoy to the north, allow the future downtilt of Wiley and PBS to the south, the obstruction of the hill to the east, and BLM land to the west. Ferguson continued that, quote, that the, quote, primary objective is to balance the traffic load across the 3 sectors and in line with Verizon's design, philosophy to minimize tower proliferation. A centrally located search ring within the coverage objective is critical. Finally, Ferguson discussed suggestions by opponents that Verizon consider multiple towers to solve the capacity and coverage issues. Employing, quote, multiple tower sites to address the capacity and coverage needs of the proposed WCF site is unnecessary and does not achieve the capacity coverage objectives for this site, asserts Ferguson, before concluding the need is better met by one WCF because Verizon does, quote, not believe that constructing multiple towers in this area is necessary or in the best interest of the community. The next portion of Exhibit 216 is a letter from Kennedy of Boabcos Consultants. Kennedy's letter begins by explaining the tower height for alternate site 2 was set at 50 feet above ground level because he understood that to be the limit in the applicable CCNRs, but that is no longer the case, so we ran a test for the site shown as 2A at 199 feet above ground level. Similarly, for alternative site 5, his understanding was that zoning capped the tower there at 25 feet, but that may not be the case. We ran an additional test at 199 feet for alternate site 5A. Addressing the drive test, which included data from AT&T and T-Mobile, Kennedy stated that is standard practice for his clients. Next, Kennedy addressed the lack of effect from the alternate sites in his latest alternate site analysis and explained that the, quote, alternative sites provide so little coverage improvement to the coverage objective area is that the reason is that they are located well outside the search ring and the coverage objective area, and measurements were taken only within the coverage objective area. Exhibit 217 from David Zelenardo is the next received during the open record period. Zelenardo said he is, quote, dismayed at Verizon's never-ending attempts at delaying, spinning facts, half-truths, and outright lies to gain the Commission's approval of this application. Zelenardo applied staff's 3-part test and firmly believes that the applicant has failed all 3 elements, supporting the testimony of Shine, Fine, and Mahoney. Zelenardo said he's suspicious of the decision to turn down the McQueen Tower, questioning whether that was done to serve the customers or to provide justification for the application. Zelenardo noted that BLM land is commonly used for wireless infrastructure, the McQueen Tower being one example out of 1,500 in the U.S., especially subsequent to Executive Order 13616. Zelenardo raised concerns outside the scope of this application before addressing the credibility of the data and the weight of the evidence. Section 7, the rebuttal period. The first submission during the rebuttal period is Exhibit 218 from Kaloji and Jones and their expert Shine, Fine, and Mahone. In it, the objectors assert that, quote, alternate towers work because existing towers work, and supplied 2 images to drive the point home. The evidence in the record shows the PBS and Wiley Towers as being able to produce coverage north all the way to the Crooked River, 9.7 miles away, which draws into doubt Kennedy's alternate site analysis, which shows effectively no coverage improvement from the alternate sites just because they are located outside the coverage objective. Continuing, objectors stated that the applicant provided no analysis of the feasibility of 8 of the objectors' 9 alternate sites, as Kennedy came to his conclusions without technical justification. The objectors dispute the validity of the search ring, as it was only presented after the submission of 9 alternative sites from the objectors, and their experts testified these alternative sites would meet the applicant's stated objectives. Quote, at this late stage, Verizon conveniently drew its boundary lines to effectively exclude all of the objectors' alternative sites except Site G, next to alternate 3. Mr. Kennedy then rejected objectors' alternate sites because they are not within Verizon's coverage objective area. Talk about rigging the outcome of the game. Objectors emphasized their alternate sites A and B on this point, as those options would not have the same visual impact on the community, would be lower in elevation than the Wiley Tower to minimize interference, and could meet the stated capacity and coverage objectives of the applicant according to the objectors' experts. However, those 2 sites were outside the coverage objective area, subsequently designed by the applicant, or designated by the applicant, but just barely. So they were eliminated by Kennedy.
John, I want to ask real quick.
Yeah.
You need a breather? Do you want to take a couple-minute break, or you get to power through?
No, we're like near the final stretch.
8 more pages.
I'm going to skim some of the last ones.
Okay.
Yeah.
Sounds good.
I can make it. What time are we?
We're good on time.
Okay. Do you guys need a break? This is, I know this is riveting reading, but.
When you're done, we'll take a break.
Okay, fair enough. Long break. Objectors stated that the search ring and coverage objective area are improper. Ferguson explains the area was identified to offload all 3 sectors, McCoyne, Wiley, and PBS, yet McCoyne has been turned down. Thus, objectors assert, quote, drawing the search ring and coverage objective area so that offload of McCoyne was considered skewed the boundaries. Additionally, because the primary objective of the proposed site, according to the applicant, is to offload capacity from the PBS tower, the coverage objective area and search ring should properly be further south. Objectors thereafter summarize and support the conclusions of their experts, Shine, Fine, and Mahone, dispute the CC&R prohibition, dispute applicant's interpretation of the county code, and draw attention to the applicant's shifting justifications, which implicates data validity and credibility issues. The objectors provide a table at pages 9 through 11 of applicant's shifting justification evidence. Pages 12 through 14 of Exhibit 218 include an additional report from Shine Fine. There, he reiterates his take-home from Exhibit 203, quote, there are numerous options using alternate sites that are technically feasible to meet the coverage and capacity objectives identified by the applicant. Shine Fine explained how towers can be placed outside the coverage objective area and provide sufficient coverage and capacity by projecting the tower's lobes inward or along the diagonal of the area of interest and projected outwards. Shine Fine described why placing a tower in the center of the coverage objective area only provides the benefits asserted by the applicant when there is a uniform distribution of headsets, which is not the case here. Shine Fine took issue with alternate site analysis of sites 2A and 5A performed by Kennedy, and that they are run with the Wiley and PBS towers at full power and should instead be simulated in its, quote, as to be run state to show the true coverage, capacity, and offload of those alternative towers. Further, Shine Fine disputed Kennedy's statement that alternative site 2A provides only some, quote, some coverage to the coverage objective area, as the data shows an immaterial difference in coverage between that location and the proposed location. Shine Fine also disputed Kennedy's statement that 2A will not provide, quote, any capacity offload to Wiley, given that 2A's coverage is only 6% less than the proposed site. Shine Fine's last point on site 2A is that while Kennedy laments the uneven distribution of that site to the three sectors, in this case, that is a positive, as it directly addresses the pinch point identified earlier for capacity and coverage along Highway 126 west of Powell Butte. Shine Fine's last 2 points relate to the McCoyne Tower and the search ring and coverage area definitions. Regarding McCoyne, Shine Fine pointed out that Ferguson stated in the application that the proposed tower will have a significant offload of McCoyne, which implies that McCoyne was the preferred server in that area for the original maps, and the new maps must, therefore, show different coverage to be accurate. Finally, Shine Fine stated that in order to meet the stated objectives in the application, offloading the PBS tower, both the coverage objective area and search ring boundaries are inconsistent with those objectives and must be moved southward. Exhibit 2019 is from Jenny Hook. Hook questions the credibility of the evidence presented by the applicant, especially in light of their plan to turn down the Wiley Tower. Hook also thanked the efforts of the 4 objectors. Exhibit 220 is from David Zolinardo. Zolinardo characterizes the applicant's Exhibit 216 as baffle them with BS and bury them with paper. Zolinardo again questioned the motives behind the down tilt of the McCoyne Tower. Zolinardo described the land acquisition process as the first step in applicant's process, followed by the analysis to justify the location it has secured. Zolinardo does not believe the applicant's conclusions are supported by the data or code language. He raised concerns with the applicant's compliance with FCC and federal wildlife law. Finally, Zolinardo applied the 3-part test suggested by staff and believes the applicant failed to meet that test and other non-resource sites would be preferable. Exhibit 221 is the applicant's rebuttal submission. This submission includes another Ferguson letter, a BLM map, a Crook County zoning map, and relevant portions of FAA Advisory Circular 70- The Ferguson letter addresses several issues. First is a response to the lack of mid-band maps. Ferguson states the, quote, primary objective for the proposed tower is to address capacity problems in the low band. Therefore, the low band coverage maps are most helpful. Regarding the lack of disclosure of tentative future sites in the application, Ferguson says Verizon is not subject to that requirement and there are no leases secured for future sites, as those will depend upon how well the new tower works once it's operational and Verizon has a better idea of, quote, the number and location of the additional WCFs needed in the area. Ferguson also addressed the comment from Shine Fine questioning the basis for changing the capacity threshold of the Wiley Tower in the 2 capacity reports. Ferguson explained that the initial capacity map included both the 700 and 850 megahertz ASEU calculations, even though Verizon's 850 megahertz license is good for only Crook County and a competitor owns the license for Jefferson County. This means the coverage area for the 850 megahertz band has less coverage until a new WCF can support 850 megahertz. Ferguson then explained why the simulations and alternative site analysis did not factor in the planned down tilt of the Wiley and PBS towers was because the proposed tower was not constructed yet. Ferguson goes into some detail defending the need to locate the tower in the center of the coverage objective area. The first reason is a general one. Verizon needs to evenly distribute the traffic between the three sectors, or one sector could exceed capacity limits, thus necessitating another tower prematurely. For this specific reason, Ferguson stated the primary objective for the proposed WCF is to resolve capacity problems in the mid-frequency band. The coverage area of the mid-frequency band is smaller than the low band, so it needs to be in the center to be most effective. Next, Ferguson addressed the potential of co-locating on the ATC Sprint Tower lower on that tower. First, the ATC Sprint Tower is too far east of the intended coverage area, meaning only one sector would be served by that tower. Additionally, such placement, according to Ferguson, would overload an additional sector, as each of Wiley, PBS, and ATC Sprint would be fighting with each other. The ATC Sprint Tower cannot be helpful to Verizon until the proposed site is constructed and can, quote, can take some of the capacity offload to the north. Ferguson's last point is that the tall towers farther away from the coverage objective area will not be helpful for mid-band coverage and will only increase interference within the intended coverage area. The zoning map of the search ring and coverage objective area submitted with this exhibit is demonstrated there. All right, section 8, applicant's final written argument. This is another section that I will add meat to in the final staff report. It's kind of a broad overview of their points. It was a 25-page submission. The final submission in the record is applicant's final written argument. The applicant's argument begins by addressing ORS 215-275 and identifying that statute as the exclusive approval criteria for the application. The applicant argues that it has met its burden to demonstrate the need for a new wireless communications facility to address both capacity and coverage deficiencies. The primary need for the facility is to, quote, provide additional capacity, particularly along Highway 126 between Redmond and Prineville. The proposed facility seeks to accomplish that by offloading data traffic from the existing McCoyne, Palo Butte South, and Wiley towers. The secondary need for the facility is to address a significant gap in coverage in the rural area north of Highway 126 and along Southwest Williams Road and the feeder roads. Noting the coverage gap applies to the mid-band frequency. The applicant asserted that the stated objectives cannot be satisfied on non-EFU zone land and that reasonable non-EFU alternatives have been considered and eliminated based on the factors in ORS 215-275 sub 2. The applicant argued that it is entitled to considerable discretion in determining the objectives and methodology for the proposed facility and whether alternative sites satisfy those objectives, citing the Sprint PCS case in Dayton Prairie. The applicant detailed the alternative co-location and non-EFU sites are considered and the reasons those sites are not reasonable alternatives to the proposed location and meeting the capacity and coverage objectives. Applicant also noted that some alternative sites, such as alternate site 3, were ruled out for zoning, non-RF reasons. The applicant then addressed the evidence and testimony of opposition experts on technical matters. First, the applicant argued that the opponent's claim that the location of the proposed facility is irrelevant is fundamentally wrong. The applicant pushed back on the claim that the search ring was manufactured after the fact. Instead, the search ring was placed in the northern part of the Palo Butte area to address the poor midband frequency coverage. The applicant also disputed the assertion that the height or elevation of the tower is a key factor. The applicant also maintained that its position has been consistent throughout this process, noting that Kennedy and Ferguson have addressed each and every issue raised by the opponents. Finally, the applicant asked the Planning Commission to consider its experts and the evidence they presented to be more credible than that of the opposition. The remainder of applicant's final written argument addressed the opposition's procedural objection. First, the applicant notes that any issues involve the true property owner have been resolved and are a non-issue, as Alexander Ranch LLC is the undisputed owner of the property, and Thomas Alexander, a sole member of the LLC, has authority to sign on the entity's behalf. Regarding the requirements of the code, those only apply to CUP applications, with which this is not. Finally, the applicant addressed the other concerns raised by the opposition parties, including radio frequency health and safety concerns, visual impacts, impacts to property values, federal and state permit requirements, and a potential bald eagle's nest. We're almost done. So section 9 here, this is another area. This is the tee up. And so in the final staff report, I teed up the test there. And so the final staff report is going to look a lot like the final decision. The final decision is, this is the area here where we're going to have hopefully a whole lot of reasoning and citing to evidence in the record as you guys come to your conclusion on this ORS 215-275. The rest of the section here are those factors. So our code mimics 215.275 in the beginning, and then these are all ones that we've added. And so, according to the case law, we can't deny the application if these aren't met. But so this is a reproduction of what was in the original staff report. Addresses all these requirements and findings. Keep scrolling through. Okay, we're almost done. And then conclusion I have right now is based on the information provided by the applicant and other information on the record and on review of the applicable state and county requirements, the planning commission may find the applicant has met their burden subject to the proposed conditions of approval below. Conversely, with the evidence presented against the application, the planning commission may also find the applicant has failed to meet its burden and the application should be denied. And then on the conditions of approval, it's what it was in the original staff report. The only thing that I added were numbers 5 and 6. Number 5, the applicant shall execute a removal agreement and provide security to the satisfaction of county council. And number 6, applicant shall coordinate with ODFW and the U.S. Forest Service and either receive an ODFW waiver or perform any mitigative measures directed by those agencies or Chapter 18.120.010 prior to applying for building permits. And so there we are. At this point, I would welcome any questions, or if you guys noticed anything that was missing or had any questions about anything in here, that'd be the time to ask. But otherwise, like I said, the goal here is for you guys to then take this document home, to look at that, to look at the staff memos, to look at the record, and to start preparing yourself to have a thorough deliberation in 2 weeks.
Question?
Yes.
In the previous staff report, I think number 3, there was a mention of the permit is not valid until receipt of the application form in the name of Alex Ranch. Is that no longer required?
I think that was submitted.
Oh, it was
Yeah.
provided. Okay. I thought it was, but I couldn't remember for sure.
Yeah, those were all submitted. Forget when, but within the last couple of months.
I have a question on some of the exhibits that were put in by the applicant and the applicant's daughter. So exhibit 2, 113, and 130. A couple of these appear to be, I'm not a font expert, but a couple of these appear to be written off the same computer, with one looking different. Has Mr. Tom Alexander been to the office to personally hand in any material?
I've seen him a couple times for this and other issues too. I think I saw him when he both delivered the letter refuting the application and then also the one that then endorsed it. And that's a peculiar situation that is very curious, but it's beyond the scope of ORS 215.275.
Curiosity kills the cat.
And so what is the county's position on who is the most, because we've heard the folks out there and we've heard Verizon, okay, and they both are here and there. Who do we decide who is telling the truth? Is that?
Yeah, I'll bring you back to, I think it was my first staff memo. How is the commission supposed to parse through the voluminous record of technical exhibits presented? Is each commission member expected to know more about low bands, offloading, and throughput than those testifying with decades of specific education experience? No. But it is incumbent upon the commission as the fact finder to assess the credibility of the evidence presented and give it appropriate weight in coming to a decision. Where, as it was before the initial evidentiary hearing, only one side presents expert testimony, some level of scientific knowledge or professional expertise is required to effectively rebut such testimony. This is true even in the absence of the scientific studies upon which the expert's opinion is based. Where there is competing and conflicting expert testimony, the rules change. While the burden remains with an applicant to establish that the relevant criteria have been met, the commission now must simply weigh all the evidence in the record and come to a decision as a reasonable person could decide. A reviewing authority such as LUBA will not second-guess the commission. So it is the commission's job to weigh the credibility of the evidence and choose which experts to believe. What is important is that in the final decision, the commission articulates how and why it came to the decision that it did, based on the experience and findings of the various and competing experts. And so this is also a section I will include in the final staff report, and then also address each of the experts' background and credentials. So it makes it flow easier, so you don't have to go from one document to the other. But excellent question. Hopefully that helps. But like I said, you need to justify or at least state why you leaned one side or the other, regarding the credibility, regarding the evidence, regarding the experts. That makes sense?
So John, you have quite a bit more information that you want to add to the final draft report, the staff report, right? Over this draft. Okay. So I guess I mean, does anybody have any more questions for staff on this? Okay.
I have a question for the commission. How painful was that process?
Slightly.
Slightly. Yeah.
Oh, more bad for you.
Like the last,
Yeah.
I think
last 40 hours of testimony.
Yeah. Right.
I think the biggest struggle is the applicant has sent multiple layered versions of different bits of data that contradict each other, and it just, that's probably my biggest hang up about, well, here's a different colored version of the same data that we want you to focus on over here. Here's a different color of the same thing. Here's a different color, but we added some lines. Here's a different, but it's all the same data, and they're trying to tell a different story with each submittal.
There was no way that this would not have been a complicated application. The fact that the McCoy Tower was turned down and things kind of changed, it made it even more complicated. And so you guys do not have an easy job, and so that's why I spent the last hour or whatever reading line by line to you what we have so far.
So let me ask you this: did they submit in their final package any more technical data?
So if you, by final package, you mean the final written argument?
Yes.
No.
Okay.
In the final rebuttal period, that is where they first introduced alternate sites 2A and 5A.
Okay. So if you were basing it off just technical data, the final rebuttal or whatever doesn't really change anything.
I think it's extremely important.
Not to say I'm not going to read
so
through it,
you know
I'm just saying
the process, the original application, there were the facts and evidence in there, and things kind of filtered up and got the arguments of the parties got kind of more specific, and you kind of narrowed in on some of the issues there. And so the final rebuttal is critically important to you guys coming to a decision, because that's the final word.
Okay.
John, this is a question. I haven't been in commission that long, but is this how it's going to go from now on? Is when you don't hear what they want to say, then they postpone it? Because we've had other things like this where it gets postponed, and it's almost like, I don't know, is it how I mean, not getting paid to be up here, you know what I'm saying? And so it's like, I feel like there's getting a lot of wasteful time.
I wouldn't say the time has been wasteful. Like I keep trying to emphasize, it's important that we have a complete record. It's important that you guys made a decision based on all the available evidence. The more that's in there, the more that's in the decision, the more justified and bulletproof your decision will be. The last thing you want to do is rush through the evidence and come to a decision based on opinion, right? Needs to be based on the facts and the substance of the record. And so I think I've encouraged this process. I think you guys have done a fantastic job. As Central Oregon Land Watch noted, this has not been easy. You guys have had to handle a lot. And I think this is all what it takes to put together a really good final decision. But so hopefully we don't get, I have not enjoyed this. This has been, I've learned way more than I wanted to.
Today, we heard the same thing
about cell
over
phones
and over again. You know?
It was all important, and it all kind of was different. And like I said, it all narrowed in on the final points. And so this has been a necessary process, even if it has been a little bit painful.
I really appreciate the staff and everybody coming out here and listening to us and putting all the work into it, because they don't get easier. Do we have any more questions for staff?
No, I just want to tell Kirk they're not all like this.
Oh my gosh, this when you come here with this today, John, it was like, really?
That's what
This is divorce court, you know? It's like, what's going on here?
Okay, well, I mean, at least we're getting all the information. We're
Right.
deciding at the best of our abilities, and I don't want anybody to be short on information. So I think that's why taking longer is better. I want to make sure if we make a decision, we made it on the right terms and we came to our conclusions properly.
I just want to say I agree with you, Chair. Kirk, if you think this is painful, having to reconsider this application on remand from Luba because the findings weren't sufficient, that would be much more painful.
Yeah, I wrote a letter to Mike McLean the other day about how frustrating Luba was. So I understand about Luba, and it's not fair.
Well, I'm saying if Luba remanded what you guys decided back to us, we would have to do it all over again. And that would,
From
the
square
second
one.
time would be less fun than the first time.
So any more questions? If not, the commission will now determine if they would like to make a motion to start deliberations or continue the deliberations to the next hearing.
Mr. Chair, I would like to make a motion to continue this hearing to a time and date certain for the purposes of deliberation only.
Second.
Okay, so a motion made by Commissioner Pont and seconded by Commissioner Steck.
Commissioner Pond, I would suggest you state the time and date certain in that motion.
Okay, the time and date being, somebody give me the date.
March,
March 11th.
March 11th,
not today, 14 days from today.
25th.
March 25th, 2026 at 4 p.m.
Commissioner Steck, seconds. All in favor?
Aye.
Aye. Let's see.
That was the 26th.
5th,
Okay.
25th.
Oh, okay. Knew that didn't sound right.
Okay,
Did I state the wrong day?
No.
You got it
I
right.
think you're good. So let's see where, sorry, question the deliberations. Question 4. Yeah.
Call for a vote.
Yeah, so I guess we're now calling for a vote after deliberations. State the motion. So we are pushing the deliberations to the next hearing on March 25th, 2026 at 4 p.m. Now we're going to call for a vote. Commissioner Giovanni,
Abstain.
Commissioner Pont,
Aye.
Commissioner Stack,
Aye.
Commissioner Kurtz,
Aye.
Commissioner Dill.
Aye.
Okay. That would be unanimous for aye.
Well,
Minus one abstain.
one abstain.
One abstain, sorry. That'd be 1, 2, 3,
Oh,
4,
it is right on my.
5. 5 for aye.
Didn't even know
So
that.
now we can move on to community development updates. At this time, I'd like to invite staff to provide any updates or departmental reports for the commission.
Thank the crowd here for sitting through us. With that,
Thank you so
see you guys in
much.
2 weeks.
We'll see you in 2 weeks and we will have our answers on. Yeah, thank you. We know it's a lot of work and really appreciate you guys making it out here. Without you, make it a lot harder for us to make a decision. So. Yeah. Yes. Ooh. We are going to take a 5-minute break. Reconvene at 6:04, 6:05. Yeah.
From
Okay, we are back from our break.
other than the ground.
This time,
It's not.
I'd like to invite staff to provide any updates and departmental reports for the commission.
Hannah, can you please pull up the? So you guys are getting this before the Board of Commissioners do. This is our monthly update. This one covers, yeah, January 1st, please. Okay. So for the month of January, on the building side, there were 144 permits issued, which is as opposed to 123 last year, so more than last year. We are also up year to date, obviously, and fiscal year to date, we are also up on the building side, so that is positive news. Not significantly, but up is up. There are, see the listings there for active permits. Scrolling. 748 total inspections in the month of January. List of large projects. I don't need to read all these off. One of the larger projects under review is the barn for Sada Ranch.
These are all under construction right now?
Yeah.
Okay.
Out on the planning side, January was a bit of a slow month for us this year. We only had 21 permit applications as opposed to 31 last year. And so we are a little bit behind last year's numbers and also behind on fiscal year. Some of the notable land use applications you guys will be surprised to hear is the Verizon Tower application. The Transportation Safety Action Plan, that's still on pause. I don't know if you remember our grant rep from the federal government, as we have not been able to contact them, still have not been able to contact them. We did get an in with ODOT's federal grant rep, and so this might be kicking back on soon. We have the Hagley mine is still to be determined. I got an incomplete letter. We have Hidden Canyon Phase 1 coming up April 8th. And then
That's been pushed out.
what's the date now?
The 25th, 22nd.
22nd. And then I think the date here is wrong for the O'Neill comp plan amendment. That should be the 25th.
Correct.
And then for the city there, you got the Barnes Butte Pool and Rec Center.
Cool.
So, hey,
Got through the grapevine.
John.
Oh, cool.
going back,
Deal.
is Hagley a new application or is it?
It's connected to it's like adjacent to the one you guys have already considered. So it's like an expansion.
Which we approved,
Yes.
which was an expansion?
Yes.
Okay.
I actually joined, you see on the status, they did a tour of the Redmond facility. I also joined City of Prineville on that tour of the Redmond pool. It's pretty exciting, but it's going to be a while down the road. You see the rest of them here. I don't need to read them all off. On site, it's pretty steady. 17 this year as opposed to 16 last year. Fiscal year, we are up, which is good. Code compliance, Lewis opened 11 cases and closed 3 in January. You can see the breakdown there with most of them being land use violations, and that covers January.
Well, can I see those violations again? Septic, waste, land use, and building. And he does, how many violations? Is that the 4 departments? And then that's what, basically there's no more violations, but building, land use, waste, and septic, that covers everything?
Yeah.
Okay.
All right. And can you pull up February? All right. So February on the building side, January was up, but February is down. We're 135 this year as opposed to 163 last year.
Is there still just one enforcement officer?
Yeah, it's Lewis on his own. He stays busy. So building permits, lower than last year, but still up year to date. It's the number of active permits there between dwellings, residential and commercial. Did 869 inspections over the month. And February is a short month. There's the large projects under consideration. Upcoming is the one in the apartments.
It's the bar over Horseshoe, I think.
Oh, yeah.
That opinion is that blue and white thing that I asked you about up on the hill, isn't it?
Yeah, the new data center.
I couldn't remember the name of it.
Opidin.
Oppidan?
That's how I pronounce it.
Okay.
What's going on at the Forest Service building? Did they have one there before?
Isn't it a remodel?
On Lamont?
Yeah. Are they just
What they call-
renovating it?
What they call the compound.
Oh, okay.
Moving down to planning,
Had their engines stored
February.
stuff.
So they're just doing a renovation of it.
So planning was pretty close to last year. 22 versus 24 last year, year to date, a little behind, and then fiscal year to date, a little behind as well. Notable land use applications there. Again, you guys are familiar with these.
Oh, and the dates are right on this one.
Sorry, this was my first time seeing this.
Hidden Canyon Phase 1 out east of town. Where?
Hidden Canyon. It's south side of Powell Butte.
On the south side of the Brasada. It's like
Yeah.
almost joining the Brasada Ranch.
It's the full approval is massive. This phase 1 is much smaller, but it'll still be it's still a pretty big application. On-site numbers for February 23, as opposed to what happened last year? There were only 6 on-site permits last year.
Scroll down.
That's good. That's a gigantic leap. Yeah, I think you're probably right. But so year to date, we're up on on-site. Code compliance, 13 open, 3 closed. There are those numbers again there, Kirk. That's the update for that. We are also in budget season, and so we're looking at our budget. The budget is we're currently looking at things. It looks better than it has in prior years. We have been doing great so far this fiscal year on the budget. Looking forward, we still have serious concerns about the long-term health of the department as it stands, but we are making a lot of improvements, and so finance team is very hopeful and optimistic about where we are, which is good news. Still concerns me a little bit, but we're doing fine.
So John, just big picture, what are your funding sources?
That's the issue. We operate almost exclusively off permit revenue. We get I believe $30,000 per year for code enforcement, but our code enforcement department and our on-site department, it's a huge struggle to stay solvent there on those two, especially for on-site. On on-site, you want to make sure that you don't have fees being too high because that encourages people not to go through the right process, which leads to health and environmental concerns. Most jurisdictions, their on-site department does get general fund money or lottery funds. Same with code compliance. And so that's something that we're trying to encourage. But the general fund bucket and lottery funds are spoken for. And I know it's a struggle countywide to keep our general fund budget balanced. And so we are trying to be creative, trying to turn over rocks, trying to make sure that we do everything we can to minimize the yearly loss.
So you don't get any general fund money?
Like I said, we get 30 grand for code compliance a year, and that's it.
Much.
It's not much. So it's important. It's hard because it's hard to anticipate permit revenue. That depends on the market and on the economy, and so it's a scary process. We're very fortunate that we have a pretty big bucket of reserves still left over from the data center development up on the hill. We also are looking good on the planning side because Will Van Vactor, when he was here, he implemented the long-range planning fee when there's a large building permit application. And that has given us some cushion and some ability to feel confident moving forward with some long-range stuff. So like I said, there are definitely positives, but it's It'd be a lot easier if we got a lot of money from the general fund.
You're getting great value here.
Yeah, right?
They're raised. John, does the county do the electrical inspections or does a state electrical inspector come here?
We do those.
And do you also do inspections for all categories for the city of Prineville?
Correct.
And they pay us for that?
It just goes through us. It doesn't go through the city.
Oh, okay. It goes direct to the county, even though it's for inside the city. Okay.
Is there an IGA for that? I don't know how that worked out. But yeah, we do all the building inspections.
Is there any talk on the second way out of Juniper Canyon? I heard maybe we might be moving in a good direction with that.
Well, yeah, so that's got some layers to it. We are moving in the right direction for the federal government to consider either giving us that land or I think it's just a grant of land for both the access for the road and for those safe spaces. Commissioner Crawford has told me that they're very excited and enthused about the safe space concept. It's kind of like a new thing, and so be really good news if we got that land. But then the next step is paying for the road itself, which is that's another can of worms. We don't have a dedicated bucket for capital improvements like that, which would be very helpful. That is the idea behind SDC, so we can eventually pay for those improvements so we can pay for growth in Crook County. But we're not there yet. Only other thing I think of is that Goal 5 update that I keep presenting to you guys. DLCD is working on the contract, and so that should be coming at some point. We're just not there yet.
Any more
Anna,
questions?
Katie, am I forgetting anything?
No, but I have a couple of things. Just a reminder that the Keystone Ranch tour is Friday. So if anybody wants to attend, they have told me that they can accommodate everybody. So if ever anyone wants to attend, I sent that itinerary out to you. It starts at 12:30, I believe.
30.
Yeah. 12:30. So if you want to go, feel free to join them.
Well, Hannah, what I was trying to look at your email. What is it for? What are they doing out there? It didn't never say.
It's a new habitat mitigation site. The company Terra West had previously focused on sage grouse habitat mitigation, but now they're expanding into, I think, general big game wildlife. And so I don't think you've had any of these, but when we get like a solar application, there's like mitigation offsets. And so currently those go through Crook County Soil and Water at the Shotgun Ranch, but this would be Keystone Ranch through a different provider. There are some differences in how they're set up. But I think it's valuable for you guys to get your boots on the ground and to see these mitigation sites. So when you have an application that's going to be impacting wildlife, you would feel confident about knowing that those impacts are being offset by the mitigation.
Who's putting it on? The people that are the people. Okay, I've seen OFW. There's going to be a bunch of different like people that would really have some weight in our job, right? Or is it just the landowner that's the applicant putting it on?
Are you talking generally or for this tour?
For this tour.
I think Terra West. So that's the company that's I think they're a national company. I think they started in Wyoming doing this stuff, and so I think Shotgun Ranch or Keystone Ranch, I'm sorry, has contracted with Terra West to facilitate this mitigation. So I imagine it would be Terra West. Are there going to be any landowners from Keystone? Do you have any idea, representatives?
No.
I don't know.
It would probably be there to give the tour.
Yeah.
Somebody.
I
thought maybe Deschutes Land Trust was there on the list or no? Maybe not.
But this is all still being done or will be done through SWCD?
No.
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 So where we've seen these before is out in post, where you have a designated ranch that has some sort of a protection on it for mitigating wildlife, right? So these are long-term projects that the property owner contracts for with companies. And where we've seen this in the past is we've had solar, not the most recently through soil water conservation, but through other, it's not the shotgun ranch. I forgot his name. There's another property owner out in Post that has a large land trust, right?
Oh, Aspen Valley.
Yes. Thank you. So, we were actually supposed to tour Aspen Valley, right around March 2020, and that didn't happen then. So, this would be the first opportunity that the Planning Commission has to go out and see what these sites could potentially look at. And so if you get an application that comes in that has a mitigation component to it and it is agreeable, it would be like an additional option for the Planning Commission to consider, where before we had some that were going, they were worked out through ODF&W and Deschutes Land Trust and Aspen Valley to benefit that ranch, right? And then one more recently was through Soil and Water Conservation District for Shotgun. This could be potentially through another company at this area. So it's an opportunity to just learn more about it, see the properties, see some of what they're doing in Crook County around that topic. Does that answer your question?
Sort of.
Okay.
Probably go.
It's still an option, but it's just like Soil and Water Conservation District is still an option. This is just an additional option in our area.
Gives us more choices.
And the applicant and property owners and everybody, right? So, yeah.
I think
One
there was a
exciting
note, bring your
aspect
muck
of-
boots.
What's that?
There was a note about bringing your muck boots.
Yeah, certainly. One exciting thing about Keystone Ranch, in my opinion, is the conservation there is in perpetuity. Like the ones that we currently do through the Shotgun Ranch, those are basically, they match, the agreements match the duration of impacts. So if a solar facility is planned for 40 years, it's 40 years of mitigation, whereas a Keystone Ranch, like I said, it's in perpetuity. So if you guys approve something with mitigation at that site, that means it'll be protected forever.
Is it done under a conservation easement or something?
I think so. We're going to find out.
Mhm.
Yeah. I mean, I would imagine that's how they do it. I've heard it's more expensive to go through them, which makes sense.
So upcoming schedules, it's, please check out your schedule, Hannah, if you want to talk about what's kind of coming up.
Before I do that, I was gonna let you know, I just sent out. I don't like Doodle Poll anymore. It's been very spammy, so I just attempted to send out a new type of poll through Microsoft, but Monty let me know that you have to sign into Microsoft, so just ignore it for now. I'm working on something else.
And if we just email you the dates, we won't be available.
That works great. I did, my poll is going to include every Wednesday, April, May, and June.
Okay.
Like every Wednesday beyond regular meetings. So just in case.
Georging season starts pretty soon.
Georging season. So that works too.
I don't know if you guys noticed, but the county is, we've launched the new website. And so,
Oh, yeah.
I think the only one I can't do is April. I'll be out of town.
I'm starting to like it. I'm starting to figure it out.
I
I don't like it yet.
No?
not yet.
Yeah, so if you have any feedback on the website, feel free to pass it along. Upcoming schedule, we have on the 25th, so in 2 weeks, we have that comp plan amendment application for the aggregate pit that John will be bringing to you, and then the deliberations from today. Let's see. Potential work session on April 8th. Nope, never mind. I'm being told no.
Oh, wait.
April 8th, we'll see if we have a meeting. And then April 22nd is the Hidden Canyon spaces.
And we're going out to Hidden Canyon on the 22nd, right? Or isn't there a site visit?
We have not discussed that yet, but is that
What's up?
something you?
22nd, so Wednesday.
I thought there was mention of it somewhere.
If there is interest, I will reach out. Someone will reach out to them. They have, the applicant has stated they are willing, to, have a site visit out there. So we'll reach out and see if that's a possibility. I know quite a few of you probably haven't been out to the site that is approved for Hidden Canyon and kind of the different phases and what is there. So we'll reach out to them and see if that would that same day, just earlier in the day, work for everyone. April 22nd. Would a different day in the evening be better? We generally have done site visits the same day as the hearing, generally around like 1 o'clock, and then have a break and then the hearing right afterwards.
Yeah, if you can find out if we can do a site visit and then
Mhm.
do a send out a poll. But yeah, I think Wednesday.
During the day, so it isn't
During the
taking
day
up
would be
your
good.
guys' evening, you know what I mean? If we could do
Yeah.
work.
Okay. We'll reach out and we'll send them an email to see if that works for them. They've requested the April 22nd date as it does work for their team. So hopefully they will be available all day.
Katie can drive the short bus.
Yes, I can, but I do still have the minivan.
Gotcha. Staff have anything else? No?
Mhm.
Is there any further business to come before the commission this evening? Oh, here,
We adjourn.
That's second.
okay. Motion made by Commissioner Seck, second by Commissioner Kurtz. All in favor signaling by saying aye or aye.
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 Aye. Meeting is now adjourned. Time is 6:27.